No one enters into a marriage with the expectation that it will end. However, people and circumstances change over time, and a once thriving marriage may find itself in turmoil. When this occurs, moving on and dissolving the marriage by filing for divorce may be the couple's best option. However, filing for divorce should not be taken lightly. It can be a very stressful and emotionally draining experience for everyone involved. It's important to not go through this experience alone, and that you have a skilled, compassionate divorce attorney at your side. Florida is a no-fault divorce state, which means that you do not have to prove one party is at fault for the marriage troubles. For example, a spouse does not have to provide any evidence of adultery or domestic violence to obtain a divorce in Florida, unlike some other states. The only requirements for obtaining a divorce is to be a Florida resident for at least 6 months prior to filing for a divorce, and that the marriage is irretrievably broken. Irretrievably broken is a legal term for saying that the marriage cannot be saved by counseling or other means. The requirements for divorce are minimal, however, the actual process of going through the divorce can be very complex. Florida divorce statutes and other court rules must be strictly followed because deviating from these rules can mean forfeiting many of your important rights. The divorce process can be especially difficult if there are children involved. The couple will have to resolve many important matters, such as where the children will live, visitation rights, and child support amounts. Resolving these issues can at times be very difficult. Often each spouse will have different views on what is best for their children. It is important to hire an experienced divorce attorney who understands your perspective and can protect your legal rights. Alimony, property, and debt division can also be difficult issues to resolve when a marriage is ending. Florida divorce law requires that the assets of a couple be equitably distributed during a divorce. An equitable distribution does not require an even split. When determining equitable distribution, the court will consider the length of the marriage, the spouse's contributions to the marriage, interruptions to the career or education of the spouses, and many other factors. In some cases, asset distribution in a Florida divorce can be very complex, with each party fighting for a larger share of the assets. In these instances, it is important to have an aggressive divorce lawyer at your side to prevent an unfair distribution of your assets. At Florida Law Advisors, we understand the delicate nature of a divorce and the need for compassionate, comprehensive legal support. The divorce lawyers at our firm work closely with each client so that they can develop a sense of what to expect both during and after the divorce. We provide all of our clients with the individualized attention they need to make this experience as easy and smooth as possible. Regardless of whether you are filing for a contested, uncontested, or collaborative divorce, we can help. Every divorce is different, and our vast experience allows us to cater our services to a client's specific situation. Whether a couple mutually agrees to the terms of a divorce, or are engaged in a fierce battle for their property and child custody rights, Florida Law Advisors can help. If you are contemplating filing for divorce, or if your spouse has already filed for divorce, contact us today to schedule a free consultation with one of the divorce attorneys at our firm.